tied. I mean, these are, and certainly I'll let the people speak for themselves, but the these are tied together really by your client's position vis-a-vis the.
I don't know until we get to the preliminary examination.
Well, right. I mean, but at least, I mean, you're telling me that, and certainly that can be true in certain circumstances, but.
Well, just for an example, Your Honor, count one is from 13 or 14 years ago. Some of these other counts are from just, from 2019, 5 years ago. So obviously it's two different times, places, and dates. I mean, it's not.
Well, right. I see what you're saying, but if I take it out of the context of what may be this case, if I had an educator or a teacher and they've been employed, say, at a period, but may have been engaging in similar conduct throughout their employment, that can be one case if that's what's happening. Now, again, I'm not saying that I know that that's what's happened in this case, but that is, at least as I'm to understand what was really occurring, is that that's what frames this as one thing.
Right, and again, if we go through a preliminary examination, the court finds that these are relatively relevant in that aspect, and then that would obviously be the court's decision to do that. I'm saying that from what I've read and what I'm seeing, I think that there is going to be severability on some of this stuff, maybe not all of it, but some of it. And obviously, whatever gets bound over, if anything gets bound over, I obviously would make that same argument to the circuit court judge if I had to, because I don't think that they are going to be relevant in that aspect. Some of these involve boys, some involve girls, and
yeah, but I don't know that the gender of a potential victim is going to be a basis upon which to sever these counts. But certainly you can make whatever argument you make, but as I understand, there is a certain element that ties them, and I think that being as I'm to understand it, and again, I'm not saying any of these as though I necessarily know, but at least what's been represented, because I was sworn out the counts 12 through 33 when they were tied it together, at least in the court's mind, was your client's position vis-a-vis these individuals. So and that's all that I can say. I don't know that to be true. I mean, certainly, but that's what I understand.
And I understand, Your Honor, what you're saying, but again, I'm saying, if the allegations are 17 or 25, I mean, I certainly think that the circumstances are totally different between those cases. So that would be our position. I mean, obviously, I would need to do a little research, and now that I've got more counts to have to get through, it's going to be up to the court. I mean, again, I would say if we're going to go from here to the preliminary examination next, that it's
counsel, the way that this court has functioned, particularly at the stage we're at now, to getting to preliminary examination, I want to make sure that each side has what discovery is going to be necessary to go forth. So I don't, unless I have to, I'm not really in the position and don't like to just push people to preliminary examination if you don't have anything or have everything, because, at least in this court's opinion, it makes it a meaningless process. Some of what you brought up, I get, but I don't, I'm never sure what's there either. I mean, if the exam were mine, then I'd have to sort all of that out. But Ms. Reiser has let's start with, the forensics on the phone, that takes time. And I'm presuming, given the timing of everything, that the people don't have all of the forensics from the phone.
That's correct, Jenna. There were several search warrants executed and electronic seized from the vehicle that the defendant was in, as well as the residence and the church office. So those items are being examined and they are not complete.
Got it. Okay.
But also I should say with caution, as in many of these cases, if it's password protected, it will take us some time to get into. So if there's a phone or a computer device that has a password to it, and it will take some time, up to months, up to a year to break that.
And so then the question becomes, counsel, I think in that regard, isn't what the court's prior position has been. If there's a device that you believe has exculpatory evidence for your client, but the authorities are having difficulty getting into that device because of the password protection, then I'm going to let them do their work. If your client wishes to then give over the password so they can get in to expedite that process, then they're free to do that. So just so that you're aware of where this court has landed previously.
Yes, sir.
Regarding that. So, well, what it sounds like to me is that you're in a position, particularly last counts and the 33 being there, attaching, and just so that I if I'm hearing you correctly, attaching individuals with particular allegations in the complaint.
I would like to know. I mean, I understand that they're minors, but I think that the prosecutor has a duty to at least say this, we're pinning this minor to count 12 and 13 or 14, 15, 16, to at least, so I know what I'm looking at for dates, times, places, or whatever. I mean, I could certainly file a motion for a statement of particulars if I needed to. I have no problem, whipping out a 5-minute motion and sending it in to be heard. But again, these are cordial things that the prosecutor should be willing to give.
Well, sometimes funny when defense counsel comes in because I don't know if it's a fight. Has it been asked for?
Yes.
All right.
Today, I asked her today. So,
well, okay, but if you ask for it today, what was the response? No?
No, I think that she will be. I'm just putting it on the record, Your Honor, because I have asked for it today. I mean, obviously, my client's incarcerated, and this case is already, over a month old at this point, month and a half or whatever it is. I mean, he's sitting in jail on a very high bond, and obviously, we're waiting on discovery from them to make a determination of a lot of what they give me is how it determines what I'm going to do. I mean, I can't guess what I'm going to do. I need to have some.
I get that, counsel, but then there's not a response that I guess is going to be necessary from the court. I mean, if you ask for things today and their response were anything that you asked for, let me ask this question. Was the response, no, I'm not going to give that?
No, absolutely not, Judge.
Okay.
But I'm saying that was before she didn't know I didn't have the 33 because it got sent to the wrong email. So that's why I don't have the 33 count information. So I didn't get it sent to me. No fault of theirs. They sent it to the wrong email.
That's right.
And so I was unaware when I walked in here. I thought I was still dealing with counts 1 through 12. I had no idea I had count 1 through 33 until the court brought it to my attention. And I was like, oh, that's a new one on me. So I had spoken to her before that. So I'm hoping that all the counts, what I asked for, and I know that it might be one of those type of things where she's saying, well, these are minors and I'm not going to, I don't have to put it in the charging document, but, I would like to have that information so I can at least, talk to my client, see what those dates and times cover.
Okay. So what it seems to me is that there's been no request that's been turned down. And
none of this.
Miss Reiser, my understanding is that everything that the people have at this point has been turned over.
Correct, and I did indicate to counsel, today that I would, send him the names associated with each count. And I will indicate for the record, count 6, 7, 8, 9, 10, in the counts, as is count 1. Criminal sexual conduct in the first degree relationship, 15, 16, 17, and 13, 14, 15, 16, and 17. I've sent him the name that that victim is associated with. It's not written in the complaint because the victim is a minor. And that's also supported by all the discovery that's been sent to him by my office, by our discovery clerk. So all of the information supporting that, the multiple penetrations of the victim for the CSE 1 counts are in the discovery that have been provided. And I thought, and correct me if I'm wrong, but at the last date, I indicated to counsel in the court that there were more victims coming forward and I would have this amended complaint done and ready to go by today's date, which I did do. So this should not.
Well, the last part of that, I don't specifically recall. I do recall you saying that there were additional victims and then presumably additional charges. So I do specifically recall that.
I have shared with counsel the names of victims that I have associated, show at probable cause that that victim is associated with that count. In some of the charges, the child sexually abusive activity, they did persuade, induce, entice, coerce under the age of 18 to engage in a child sexually abusive activity. It doesn't call for a victim's name. It calls for a child under the age of 18. So I have charged one of those counts for each victim that he solicited them under the age of 18 to send images and videos of them masturbating to him. So there's one for each victim in the discovery, each victim, each location, and it does occur from 2014 through 2024. So when counsel's ready, I think the best thing to do is to have a preliminary exam. I don't advise that there's exculpatory information on one of the electronics, but if we can't get into it, he's requested a FBI report on page 11 of 17 of the troopers, what I believe to be a well-written report, indicates that he had contact from other agencies. On the morning of 10/17/2024, Special Agent Adam Christensen of the FBI Detroit contacted me about a tip they received from Holly on 10/7/2024. And so we'll obtain that from the FBI if we can. We don't have it in the discovery now, but if there is a report, I'll obtain it, and we'll forward it.
So just so that I'm clear, you're going to provide to him the names associated with each count.
I already have sent him an email with the names that I intend.
Okay, and that was sent
That was just emailed. You should receive it.
today.
Yes.
Okay, so everything's happening today. All right, that's fine. So that would take care of that issue. And then it would also seem to me, counsel, to take care of the issue regarding potentially at least some of the timing and other things, because that can then be tied up into reports, right?
Yes, sir. Hopefully.
All right. So what do you guys want to do today? Because the way we keep standing here, it's going to be Thanksgiving.
Can I have a second to confer with my client real quick?
Certainly.
If we had one more PCC just to go through all this stuff to make sure that we have everything that we need to be ready, could we do that? If not,
I mean,
I have no
counsel, if you ask for an adjourned PCC, I know there are other courts around the state they see. It behooves no one if the parties aren't ready to go. So if you need an adjourned PCC, I don't have a problem doing that. It's just a matter of what time you're looking at to make sure you can get through everything. And so.
I think that, in light of the new information that we have, just so I can get it to my client, let him go through it, get some notes. I'm going to need some explanations, not that it's a problem, but I'm on the other side of the state, so I have to make my way over here to do that with him. So if I could just get a little time to get him that information in the new emails that were sent today, and
Is there anything else from either side?
No,
Your Honor.
No? Okay, thank you. Court calls the case of the people versus Zachary Radcliffe.
Your Honor, James Thomas, or Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up, and to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point, none of
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
Never.
But if you, okay, then fine. You want to file a written all the time in the world, I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
But the only thing, I'm out of the country from the 21st to the 28th of January.
Set probable cause, I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes,
my staff.
I suggest we set an exam date.
It's not going to happen until discovery is all complete. He's saying discovery's not, what I'm going to do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not going to set it. I'm going to hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode protected.
And then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's going to happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
No, I didn't say that.
Well, is there other notices out there for anything else that you're doing with other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. That's what I'm hearing. Anything else?
Oh, thank you.
No, sir.
Wonderful. We'll see you on the 30th.